Detective Ricketts, you were with ACCPD, is that correct?
That's correct.
Okay, and during the time of this investigation, you were with ACCPD, is that right? Would you agree that ACCPD dropped the ball on this investigation?
No.
Okay. You believe ACCPD followed up on all leads,
Yes.
confirmed all information?
I think so. I would like to add something to that if you would allow me to.
I can't answer any questions. We could talk about it after those, if that's okay. This time.
No, I think I'll answer that question. Yes, I wish, if you look back at any case 25 years ago and look at it with fresh eyes from 25 years ago, yes, things would have been done totally different, I think, with some options and things that would have happened. Everything that I can say to, and I will not answer on behalf of ACCPD, but on the days that I was a part of this case, I will say, I think, yes, we did. But I think if you look at anything 25 years back, I think if you look at something I did last week, there would be things that I would like to improve on. Okay. But I don't think drop the ball would be a word I would ever use.
Sure. Do you believe ACCPD followed the evidence appropriately?
Yes, sir. The evidence, to my knowledge, I believe they did.
Okay. And I'm assuming that you met with the prosecution before you testified today, is that right?
That's correct.
Okay. Do you or ACCPD feel a need to justify why Chris Melton was not arrested?
No.
Do you or ACCPD feel the need to have to defend Chris Melton?
I don't believe I'm here defending Chris Melton.
Sure. So that is a yes or no question.
Then please repeat it.
Yes, sir. Do you or ACCPD feel the need to defend Chris Melton?
No.
Okay. Do you or ACCPD feel the need to defend the state's case?
No.
Okay. So I'd like to ask you some questions about a couple of things that you talked about on direct examination, okay?
Okay.
For starters, would you have any reason to disagree that January 19th, 2001 was 9,153 days ago?
Sounds appropriate.
Okay. And I'm going to use this whiteboard over here.
Yes, sir.
So 9,153 days since 1/19/01. Fair?
Sounds correct.
In 2001, can you tell us what team won the Super Bowl?
I cannot.
Okay. In 2001, can you tell us what team won the World Series?
No.
In 2001, can you tell us what your favorite song was?
No.
Okay. So no to Super Bowl, and forgive my handwriting. It is terrible. No to World Series. No to favorite song. My handwriting is terrible. And this is no to favorite song. Correct. And you would agree that your notes say nothing about Mr. Melton picking anything off of his hands. Is that correct?
No, sir. I'm going with that from the recollection of the audio cassette tapes from that day.
So your statement to this jury is that based on the audio cassette of that day, it refreshed your recollection that Mr. Melton was picking items off of his hands.
Yes, sir. You asked me about the Super Bowl. Not an NFL guy, not a baseball guy.
That's fine.
The crime scene for Tara Baker, I'll never forget.
Mr. Ricketts, that's a yes or no question.
Well, repeat your question, please.
The witness is allowed to explain his answer.
May I be heard on that, Your Honor?
You may be, yes.
I would disagree with that. the witness on cross-examination, my job is to posit to the witness yes or no questions. If the state wants the witness to elicit further testimony, they do that on redirect. At this time, Your Honor, I pretty much give the witness what the answer is. They can answer yes or no, and we decide which direction we go from there. So I would ask that the witness is not allowed to control cross-examination, to control Mr. Faust's rights to cross-examination, and we're allowed to ask the witness leading questions that the witness answers appropriately.
Okay, so this is not about witness control. This is about what the law allows. And cross-examination questions are yes or no questions, certainly. But the law allows a witness to answer yes or no and then explain if he or she chooses to make an explanation. And so I'm going to overrule your objection. He is allowed to explain if he chooses to. If there are further objections the court needs to make with regard to those explanations, I certainly will hear it.
Yes, ma'am.
If you'll ask the question again, Mr. Cruz. Thank you.
Sure. And I withdraw that question, Your Honor. I withdraw that question. But my understanding is the audio is what refreshed your recollection in regards to what was on Mr. Melton's hands.
Yes,
Okay. And that audio is from January 19, 2001.
that's correct.
Okay. And you've already listened to that audio because the state provided you with a copy. Is that correct?
Yes, sir.
Okay. And if you were to hear that audio, you would recognize it. Is that fair to say?
Yes.
Okay. Court's indulgence.